PDP member representing Idiato North-South Federal Constituency in the House of Representatives, has rejected the tribunal ruling which sacked him and headed to the Court of Appeal. Following his appearance on the morning show on Monday, we're now joined by Felix Obiosio, member, Imo State All Progressives Congress legal team for national and state houses of assembly election petitions for a right of reply. Good morning and welcome to the morning show.
Well, very quickly, if you can hear us.
And thanks for having me.
Yes, Felix Obiosio.
Thank you. Good morning. Thank you for having me.
This is, meant to be a right of reply interaction with you. Ugochinyere was on this program, and he said he's going straight ahead to the Court of Appeal because the tribunal, erred in his own view, and that in any case is the APC governor in Imo State, Ugochinyere, who is behind, his travails, either in court or out of court, and all of that. What do you have to say to those allegations? More so, as the tribunal had said, he will be excluded from the supplementary polls in 55 polling units that has been ordered. But what's your response to some of his claims?
Right, it is his constitutional right to approach the Court of Appeal to ventilate his grievances. If he's not satisfied with the judgment of the honorable judges of the tribunals sitting in Maraba, it is his constitutional right to approach the Court of Appeal to challenge the outcome of the judgment. In any case, the issue as to whether Ugochinyere was qualified to be part of the 25th February 2023 general election has been clearly resolved by the Supreme Court in Alaboso and INEC, in which the Supreme Court said, look, all the primary elections conducted by the PDP in Imo State were primaries that were unknown to law, they were null and void, and of no effect whatsoever. So, in the eyes of the law, nothing could come out of the primary elections that were conducted by the Imo State PDP at the Aladima Shopping Mall Plaza. The primary elections were null and void, and it goes to the root of qualification for a person to contest in the election. So, Ugochinyere was not a product of a valid primaries that could produce a valid candidate to participate in the 25th February general elections. So the court, in considering the judgment of the Supreme Court in Alaboso and INEC, held that INEC was wrong in including Ugochinyere in the election because the primaries that produced him was voided by the Supreme Court in Alaboso versus INEC. So there was no basis for his participation in the 25th February 2023 general elections. So what INEC could not do by abiding by the provisions of Section 84 sub 13 of the Electoral Act is what the Honorable Tribunal has done. And that is valid in law. So if Ugochinyere is challenging the outcome of the judgment of the Honorable Tribunal, he has his right to appeal to the Court of Appeal and is well within his rights. But to say that the distinguished governor of Imo State, His Excellency Hope Uzodinma, had influenced the outcome of the judgment of the tribunal is to say the least, ridiculous and a statement that is unbecoming of a legal practitioner. We expect that as a legal practitioner, Ugochinyere should have respect for the judiciary. And if he has any grievances, he is within his right to approach the Court of Appeal to challenge the outcome of the judgment. But the issue is whether Ugochinyere was validly nominated. This issue of nomination has been settled by the Supreme Court in a litany of cases. For example, in Jegede and INEC, the Supreme Court has said that the issue as to whether a person is qualified can be an issue of pre-election or post-election matter. Because our petition was predicated under Section 134 sub 1A of the Electoral Act that says a person whose election is being questioned can be so questioned if at the time of the election he was not qualified to contest in the election. That is the provision of Section 134 134 subsection 1A. And that was the ground for which we approached the tribunal to challenge the outcome of the 25th February election that brought Ikenga Ugochinyere as the winner of the election. Our argument was a simple one. Whether, having regards to the provision of section 84 sub 5 paragraph CI of the Electoral Act, Ikenga was a product of a valid primary election that could qualify him as a candidate in the 25th February elections. And the answer is no. Ikenga was a product of a void election. INEC refused to abide by the provisions of section 84 sub 13 in excluding Ikenga Ugochinyere and the PDP from the 25th February elections. That is what the court has done. Because in Jegede and INEC, in Alaboso and INEC and two others, the Supreme Court has nullified and voided the primaries that was conducted in Aladima Shopping Mall Plaza, which was the primary election that produced Ikenga Ugochinyere as a candidate of the PDP. So having nullified the primaries that took place at Aladima Shopping Mall Plaza in Imo State, or Imo State, there was no basis for the inclusion of Ikenga Ugochinyere in the election. So that is on that basis that the tribunal nullified this election and return and has ordered a rerun because the elections were not conducted in over 55 polling units, having over 21,000 registered voters, with over 19,000 PVCs collected. You cannot shut your eyes to these facts, and Ugochinyere parades that His Excellency Hope Uzodinma had caused his predicament at the election, without producing or supplying facts to support his allegations.
All right, we hear you, Mr.
It's preposterous, and I think Ugochinyere should withdraw his statement against His Excellency the Governor.
All right, Mr. Obiosio, thank you very much for stating your side of the argument in this case. But I'd like to ask you, in those 55 polling units where elections were not held, why were they not held? Could they have been held in terms of the security status of those areas? And then in terms of the pre-election matter of whether he was validly nominated by the PDP because of where his primary was held, was his local government area safe to host primaries or for people to come out to vote?
The reason for not holding the election in the 55 polling unit having over 19,000 PVCs collected is that election materials were not supplied to these polling units. INEC staffs were not deployed to these polling units.
Why?
There was no way election could have been conducted.
Why were
for whatever reason stated by INEC.
Not anything to do with security.
That is best. As far as I'm concerned, there is no issue of security in these 55 polling units where elections were not conducted. There is no way in Nigeria where you don't have security issues here and there. It was not so much that elections could not have been conducted in these 55 polling units, having over 19,000 registered voters who had collected their PVCs and were ready to vote at the elections. So not conducting election in 55 polling units, having over 19,000 registered voters who were ready to participate and cast their vote at the election was a situation that could not have resulted in the declaration of Ikenga Ugochinyere as the winner of the election. Those are the facts. So the situation in Imo State, in particular this 55 polling unit, were not such that elections could not have been conducted there. But even INEC staff who came and testified at the trial had said and confirmed to the court that elections were indeed not conducted at these polling units. Therefore, you could not have disenfranchised over 19,000 registered voters who were ready to cast their vote at the election, and then you go ahead to declare someone who was not a candidate in the election. Because the law did not recognize him as a candidate at the election, he could not have been included by INEC on the ballots. So his inclusion ab initio was a wrongful inclusion on the ballot. It was a null and void inclusion. And the tribunal was right in its unanimous decision in ordering that he was not a candidate at the election. PDP could not have validly nominated him. He was not validly sponsored because the issue of sponsorship, the issue of nomination, it's a threshold issue that goes to the qualification to contest an election in section 65, sub 2, sub B of the Constitution. And Section 1341A makes it a ground for approaching the court to challenge the outcome of an election, which we did.
Okay. So this is one of the defense he's putting forward. He's citing Section 285, sub 14C of 1999 Constitution that says only allows a political party to challenge the decisions, activities of INEC disqualifying its own candidate from participating in an election or to comply with the provisions of the Electoral Act. So what he's just saying invariably is that with that section, you guys are just meddlesome interlopers. I mean, respond to that. This is part of his challenge.
Well, we are not meddlesome interlopers because the court held in Jegede and INEC that if the pre-election matter is such that goes to the root of disqualification to contest in an election, then the matter can be a pre-election matter and also a post-election matter. In our case, the issue was whether Ugochinyere Ikenga was validly nominated, was a product of a valid primaries. And the Electoral Act in Section 84, sub 13 is clear on the consequence of not being a product of a valid primary election. There is no substitute to it. There is no alternative to it. Once you are a product of a void election, once your primary election was not conducted in accordance with the provisions of Section 84, sub 5, paragraph CI of the Electoral Act, then your sponsorship is unknown to law. Your nomination is unknown to law. And the issue of sponsorship is a constitutional issue. It is a matter that goes to the qualification of a person to participate in an election. And Ikenga did not meet that requirement. And the court rightly excluded him from the election.
I also want to ask you a question based on the back and forth between Ikenga and the governor, you know, because he made a lot of allegations. But there's also a story making the rounds that Governor Uzodinma was talking to the head of the House of Rep and saying, why should they give Ugochinyere, you know, a very juicy position, in quote. Why was that the case? Why was the governor going to oversee what the House of Rep was doing as regards to position? Because there was a story like that in the National Daily. I'd like to throw more light on that.
The governor of Imo State is the head of APC in Imo State, and he also is the chairman of the APC, Progressive Governors Forum. And politics, of course, you know, is a game of interest. So if the governor is advocating that party members should be considered for certain appointments, I think the governor is within his rights.
Is it not being a meddlesome interloper? Is it not being a meddlesome interloper in the case of Ugochinyere, because he's from another party and he was given a position in the House of Representatives, which is the House of Reps' decision on that? Why must the governor go interfere and be calling the Speaker of the House of Rep to order as regards that situation?
The governor has already made his recommendation. In any case, where in the law is it that the governor cannot make recommendations to the Speaker of House of Reps on who, you know, the competence of the person to be appointed as a committee chairman? Where in the law do we have such restriction? The governor has made as a leader of the party in Imo State and as the chairman of the Progressive Governors
interloping in Ugochинyere's case?
Obiosio, there is a matter that I need you to address before we go, and it's as follows. That tribunal judgment came about a week. Are you with me? That tribunal judgment came about a week after the ruling in the presidential election petition. And one of the issues there about nomination of candidates by the Court of Appeal was that the matter raised by the petitioners, by one of the petitioners, was a pre-election matter. That the court was not going to inquire into that because it will raise issues of locus and all of that. And one argument that Ugochinyere made here, and his supporters also, was that wasn't that tribunal aware of the ruling in that particular case, which is, you know, just very fresh. But you are citing the Jegede case, which came before, right? But the latest in time is what Ugochinyere is quoting. And you know the principle in law in any case. So that's what you really should quickly address, because it's one of the grounds of the appeal that he was pointing to. And then in any case, we understand that on the streets of Idato Federal Constituency, youths were protesting, saying that they are in support of Ugochinyere and that no court of law can remove him from the position that he occupies in the House of Reps. Is the area now peaceful? Are the protests still continuing? All
right, quickly, let me address the issue of the precedent. Now, the decision, the facts before the presidential election petition court are not the same with the facts in the election petition that we presented at the tribunal. Now, the facts are not the same. The presidential election petition court decided on the issue that is not the same in fact with the facts that we presented at the tribunal. In fact, the law is that cases are authority for the facts which they decide. And so the decision of the presidential election petition court delivered before the tribunal's decision in Ugochinyere case are not the same in fact and are distinguishable. In fact, the matter before the presidential election petition court was whether issue of double nomination could disqualify Shettima from being a running mate of His Excellency President Tinubu. And the issue before the tribunal is whether there was in fact a valid nomination. It was not the issue of valid primaries that produces a valid candidate for an election that was before the presidential election petition. It was the issue of double nomination. In other words, there is a sponsorship of a candidate, but whether a double nomination will operate to disqualify a candidate in an election was what was before the presidential election petition court. What is before the tribunal is different facts entirely, and that is whether there was a valid primaries in the first place that could produce a valid candidate in an election. So the decision in the presidential election petition court, which is a decision of a court of appeal, cannot override the decision of the Supreme Court in Jegede and INEC. So in applying the judicial precedent, it is the decision in Jegede and INEC, which is a decision of the Supreme Court, that takes precedent over the decision of the presidential election petition court, which is a court of appeal. So you cannot cite a decision of a court of appeal to override the decision of a Supreme Court in Jegede and INEC. That's the law. That's the law. So it is wrong for Ugochinyere to rely on the decision of a court of appeal in order to drive home his claim that the issues were one of pre-election matter and could not have been canvassed at the tribunal. Whereas in Jegede and INEC, that's the Supreme Court judgment. The Supreme Court said, you can ventilate the issue of qualification of a candidate in an election at the election petition tribunal. That's the decision of the Supreme Court. And it is wrong to say that the decision of the presidential election petition court should bind the tribunal.
I get your point.
When there is...
Quickly, is there peace in Idiato federal constituency? Now.
There is peace in Idiato North and South constituency. There is... The protesters are those who have been arranged by Ikenga Ugochinyere to display to display, a kind of a drama to say there is no peace in Idiato North and South. But there is absolute peace. There is absolute peace in Idiato North and South. What is happening to Ikenga Ugochinyere is one that in the Igbo language we will say, Okore rueru surogodo. That is what has happened to Ugochinyere.
You sound like a line from New Masquerade. That sounds like a line from New Masquerade. So please interpret your proverb before you go quickly. Can you interpret that?
A child who wears a rope untimely, when the wind comes, it blows him and the rope away. That is what has happened to Ugochinyere Ikenga. Okay. Yes, he was not qualified, and the judgment of the tribunal has blown him off because he was not a candidate at the election. PDP cannot be a candidate; it cannot participate in the election. Okay,
I get your point. After all, Achebe told us that proverbs are the palm oil with which words are eaten. Thank you very much, Felix Obiosio, for joining us on The Morning Show.